Welcome to our HR Huddle One-to-One with Keeley Baigent of KSABLaw. Today we're discussing how to manage protected conversations. So thank you for joining us today, Keeley. Pleasure to have you again.
Oh, thank you for inviting me.
So we all know disciplinary and performance procedures can be lengthy and don't always result in an employee's dismissal, or they can expose the employer to an unfair dismissal claim. Is there any way that an employer can agree an employee's exit without the risk of a claim?
Yeah, so this is quite a common question I am asked because, as you've said, the procedures that need to be followed to ensure that a dismissal is fair can be quite lengthy and time-consuming. If an employee has 2 years service or more, then a fair procedure has to be followed before they are dismissed. Otherwise, it exposes the employer to an unfair dismissal claim, and the employer will have to pay compensation to the employee. And obviously, the procedure that needs to be adopted depends on the reason for the dismissal. So if, for example, you are dismissing an employee for misconduct or for performance, then other than if it's a gross misconduct situation, quite a lengthy warning procedure has to be undertaken, particularly with regards to performance or capability issues. So in that regard, you're looking at a procedure that involves advising the employee that of their performance shortcomings, of monitoring the employee's performance against set objectives or criteria over a set monitoring period. If the employee then falls down and doesn't achieve the objectives, then you're inviting the employee to a formal capability or disciplinary hearing, at the end of which they could be issued with a first written warning, which they can appeal. Then the procedure goes on, so you're monitoring an employee again against the set objectives and criteria during the monitoring period. If they fail to perform to the required standards, then again, they're invited to a further formal hearing. A final written warning then can be issued, which they can appeal. And then the final stage is then monitoring them against the criteria again during the monitoring period. If they fall down, don't achieve those objectives, then they're invited to then the final hearing, the outcome of which could be their dismissal. And again, they can appeal that dismissal. So that is a lengthy and time-consuming process. There needs to be monitoring, review meetings during the monitoring periods, and the procedure could take 3 to 6 months easily. So that's the reason really that people or clients ask me, well, what can we do about this? Can we shortcut this process if at all possible? So the concept of a protected conversation was actually introduced in July 2013 via section 11A of the Employment Rights Act. And what it does is it enables an employer to enter into a protected conversation or pre-termination negotiations with an employee to try and agree their exit with them on agreed terms. So the legislation intended to make it easier for employers to actually initiate these settlement negotiations and, as I say, try and agree with the employee terms on which they exit the employment without having to go through a lengthy performance or capability process. And the aim of the legislation is very much that if an employer enters into these protected conversations, then those conversations are protected. So what that means is that they shouldn't be admissible in any future employment tribunal hearing further to an employee bringing a claim against the employer. So in effect, they are confidential or protected. So yes, if you can enter into those, then we can try and avoid then these more lengthy formalised processes.
Fantastic. So how does a protected conversation differ then from a conversation that's conducted on a without prejudice basis?
Yes, okay, so most people will have heard of without prejudice discussion. And the common belief is without prejudice discussions are the same as a protected conversation, because the aim of both is to ensure that those conversations or negotiations are not then admissible in any future tribunal or court process. However, a without prejudice negotiation or discussion can only take place if there is an existing legal dispute in place. So if there is no potential claim or legal dispute that is in fact present at the time, the parties cannot enter into without prejudice negotiations. And what that means is those negotiations then can be admissible in any future tribunal or court hearing. So what the protected conversation does is it enables an employer and employee to actually enter into these protected conversations, even if a legal dispute has not arisen. So you may not have dismissed the employee, you may not have actually even alerted the employee to a potential matter of concern at the time that you enter into these negotiations with them. So there doesn't have to be an existing legal claim or dispute in place before you can enter into these protected conversations. And that's the difference between the two concepts.
Okay, brilliant, thank you. So when would it be an appropriate time for an employer to ask the employee to enter into a protected conversation?
So the option given to the employee of entering into these protected conversations should be held or should be given to them at a meeting. Now, the meeting could be held at any time after the employer has identified the issue or the concern. So it might be that the employer considers further to receipt of information from managers, that there's a breakdown in the employment relationship, or that there is a conduct or capability issue that's been identified. So at that point, once the issue's been identified, then an employer can ask the employee to attend a meeting, and at that meeting, the matter of a protected conversation can be raised with them. Now, what the employer states at this meeting should be scripted in advance, because it's actually quite an important meeting. So the employer needs to feel confident about what it is going to say to the employee at that meeting. So the first thing the employer must do is identify the issue and alert the employee of the issue of concern. So if that's a performance or a conduct matter, then they need to tell the employee that this is the matter of concern that has arisen. And the employer will then need to say, further to the identification of this, what we've decided to do is that we've got no alternative but to commence a formal process to deal with that matter. And then that formal process needs to be fully explained to the employee. So if it's a conduct issue, you'll be saying to the employee, this matter has been identified. What we have no alternative but to do is to commence a formal disciplinary process. That will involve you being invited to a formal disciplinary hearing, the matter discussed, and that could result in whatever it is. So it might be dismissal on notice, or it might be a written warning. But the whole procedure needs to be explained, so the employee is fully aware of the risk that their employment could be terminated and they could be dismissed if the full procedure is followed and the performance issue isn't resolved, or the employee doesn't improve their performance, or if they fail to improve their conduct sufficiently. So they're fully aware of the potential outcome of the formal process. So then the employer moves on to say, but there is another option. Right. We can deal with it in another matter. We can deal with it in another way. And that's called a protected conversation. And a full explanation of a protected conversation then needs to be given to the employee. So you'll be saying to the employee, the option open to you is to engage with us with a protected conversation. This means that we try and agree the terms on which you exit your employment with us on agreed terms. There is you're not being forced into this situation. It's entirely up to you. It's an option open to you. But if you don't engage in those protected conversations with us, then we will be going down the formal route. So please have a think about that. After the meeting or at the meeting, the employer then should provide the employee with a letter setting out what's being discussed and also setting out the clear terms on which the protected conversation is being entered into. So that might be in the letter detailing the proposed termination of employment date, whether or not the employee will be required to work out a notice period or be paid in lieu of it, the sum that the employer is offering as compensation to settle any existing dispute or to enter into the agreed termination. And if the employer is going to be offering any factual reference to the employee. The letter should also detail that the employee is required to enter into a settlement agreement with the employer. That would be the next step if they wish to engage in this protected conversation. And a detailed explanation of what a settlement agreement is should be included in the letter.
Okay, I think most of us will know what a settlement agreement is, but it would be useful if you wouldn't mind just reconfirming that for us.
Yeah. So as we know, a settlement agreement is a legally binding contract between the employee and the employer. And what it does, it prevents the employee from bringing any claim in respect of their employment or the termination of it in the employment tribunal or in a court. So it's a document that prevents the employee from subsequently bringing a claim against the employer. The employee will be required to take legal advice on that document. It will only be a legally binding document or settlement agreement if the employer takes legal advice. Right. And the advisor does have to sign a certificate confirming that they have provided the employee with advice on the document. It is usual for an employer to contribute towards the legal costs in the employee taking advice on the settlement agreement. And the usual contribution sum is around £350 plus VAT at the present moment. This is the only way you can settle employment claims. The legislation is clear that it can't be done in open correspondence or by way of a written or a oral agreement. A settlement agreement is the only way that you can prevent an employee from bringing a claim in the employment tribunal.
Okay, thanks for clarifying that, Keeley. So how should the employer proceed if the employee agrees to enter into a protected conversation?
Okay, so if we haven't already sent to the employee a draft settlement agreement with that initial letter, which we may not have done, the employee should then tell us, yes, I'd like to engage in a protected conversation, please. Please send me the full settlement agreement so I can consider it. We will then provide them with the settlement agreement setting out the terms of the proposed agreed termination, including the termination date, what compensation we're going to be offering them, whether they should be required to work out a notice period or be paid in lieu of it, any holiday pay that we're proposing to pay that's accrued but not taken, those kinds of things. So the settlement agreement will be sent to them, and then they will be required to take legal advice on that document. Now, the solicitor or the employee may then engage with us and say, we're happy with the settlement agreement, we'll sign it off. Or they may say, we'd like some more money, please, or we'd like the terms of the agreement changed in some way. So we then enter, if that's the case, we enter into negotiations about that. If an agreement can be reached, then both parties sign the settlement agreement. That's the employer representative and the employee. The document is dated and the solicitor is required to sign their certificate. And once that is all done, then that is a legally binding contract in place.
Okay. But what if the negotiations during the protected conversation break down?
If they break down, then we simply revert back to the original formal process. So if one hasn't been commenced yet, then we advise the employee that further to the breakdown of the protected conversation, we're now going to commence that formal process that we originally spoke to them about. If we're within a formal process, that recommences or continues. And if we haven't, or we're not intending to commence a formal process or deal with the matter in another way, then we start off, we proceed where we started off, in effect, as if the protected conversation hadn't been entered into at all.
That makes sense. So if the employee is subsequently dismissed, couldn't the employee try and use the fact that the employer asked them to enter into a protected conversation as evidence that their dismissal was predetermined and so unfair?
Yeah, I mean, this is a common question, because that's what an employee surely would try and do. They'd try and say, well, you tried to agree an exit with me. You tried to exit my employment with my agreement. And surely that's evidence that you were going to dismiss me anyway. Well, that's the essence of Section 111A of the Employment Rights Act, the concept of a protected conversation. It is so that those negotiations or those conversations cannot be used as evidence in the employment tribunal to bolster or to bring the unfair dismissal claim. So they may try, but they won't succeed.
Okay, good to know. So when would a protected conversation not be confidential and so could be used as evidence in a claim brought by the employee?
Yeah, so there are exceptions.
Of course there are exceptions.
So we do have to tread very carefully. So really this section of the Employment Rights Act, Section 111A, had in mind unfair dismissal claims. And therefore, if an employee subsequently brings a claim for or one of the automatically unfair reasons, so for example, that their dismissal was on the ground of whistleblowing, or it was because they asserted a statutory right, or if it was connected with pregnancy, or if it was in relation to health and safety, then the protected conversation could be used as evidence of unfairness in the dismissal, if it obviously supports the allegation that the reason for the dismissal was one of the automatically unfair reasons. Also, if the employee brings a claim for discrimination, so that's on any of the protected characteristics. So if the employee pursues a claim for discrimination, then they can refer potentially to the protected conversation to support that claim. If, of course, some kind of allegation of discriminatory act occurred during that protected conversation, they will then be able to refer to it in the employment tribunal. And then the third thing we need to be really careful about is that a protected conversation can be referred to in tribunal proceedings if there is an allegation that the employer has behaved unreasonably or inappropriately during those conversations or negotiations, if there has been in any way any improper behaviour. And what constitutes improper behaviour is ultimately for the tribunal to decide, but it can include the following. So it can include fraud, undue influence, or blackmail. I mean, they're pretty obvious, aren't they? So if an employer is blackmailing an employee to enter into this situation's protected conversation and exit their employment, then of course that conversation is going to be heard by the employment tribunal. Any form of bullying or harassment that occurs during the protected conversation means that it will no longer be protected. Any physical assault or threat of violence, again, will make the conversation not protected. And one of them that we must really take note of is if there has been undue pressure put on the employee during these negotiations. So undue pressure may include where the employer fails to give the employee a reasonable amount of time to consider the offer. So if it simply says, right, if you don't accept this offer and enter into a settlement agreement within 2 days or 3 days, you're going to be dismissed, then that would be undue pressure. And what the ACAS code does say is that the reasonable amount of time should be at least 10 calendar days for an employee to consider an offer put to them under a settlement agreement. So that will give them time to consider the financial offer put forward and take legal advice on it. So an employer shouldn't try and push these things through too quickly, because it might face an allegation of undue pressure, which would ultimately mean then the conversation is disclosable as evidence in the employment tribunal. So the legislation is there to help employers try and negotiate exits with their employees, but tread carefully.
Brilliant. Thank you, Keeley. That was a really informative session. Yeah, so really enjoyed it. So if anybody has any employment law issues or questions, Keeley would be happy to speak to you and answer any information. So Keeley's contact details will be on the end of the video. Thank you for listening, and we'll see you again soon.